Good morning and welcome to this UK-India Business Council webinar, What You Need to Know About India's New National IP Policy. My name is Aina Gupta, Research and Policy Manager at UK-India Business Council, and I will be moderating this session. India announced its first ever National Intellectual Property Policy this May, seeking to promote a creative and innovative India. The policy, which is in compliance with World Trade Organization's agreement on trade-related aspects of IPRs, aims to sustain entrepreneurship and boost Prime Minister Narendra Modi's pet scheme, Make in India. Government's new policy is just one indication that India is trying to catalyze the full potential of intellectual property for India's economic growth and socio-cultural development. And the efforts are in line with Prime Minister Narendra Modi's efforts to make it easier for foreign companies to do business in India. In this webinar, we will discuss what the document means in practice and what it means for UK businesses. Before we begin, I would like to familiarize you with the toolbox on the right-hand side of your screens. Just to let you know, everyone will be on mute during the course of the webinar, but if you do have a question, please type it into the little bracket on your toolbox in the Please Type Your Question Here section and send this to me. I will take it up during our Q&A session at the end. I am delighted to welcome Anshika Jha, UK Intellectual Property Office's attaché for our speaker for today's webinar. Anshika promotes partnerships between the UK and India on IP matters and provides practical support to UK businesses. Anshika is a part of a network of IP attachés around the world. They help UK SMEs navigate their way through the maze-like IP systems in regions like India, China, and Brazil. I would now like to welcome Anshika for her insights on India's new intellectual property policy.
Thank you very much, Aina, for that introduction. Welcome, everybody. Thank you very much for joining this webinar today. I know it may be a holiday for some of you on account of Eid, so thank you especially for joining. Aina has already given me an introduction, so let's just jump straight into the webinar. So what's new? The most recent development in the Indian IP scene is the announcement of the National IP Policy. And this happened in May this year. Let's have a look at what this policy is all about. What's actually changed, and does that mean anything different for all of you? Before I start, let me give you a little bit of context. Why has this policy come out, and why has it come out now? So if we go to the first bullet, I'm just going to give you a little bit of background. What has India's IP system been so far? Well, traditionally, India has not really had an IP system. India does not really believe in an IP regime. India believes in the free flow of knowledge and genuinely thinks that any IP regime and the protection of any intellectual property actually goes to block knowledge and makes the prices of essential commodities more expensive and out of reach for India's poor citizens. So that's the basic background. That's where India's IP system really began. But India joined the World Trade Organization, and with that had to bring all of its laws in compliance with the TRIPS obligations. So up to 2005, India had to make all of its laws compliant with TRIPS, and that's what it did. Many of us may beg to differ that not all the laws and not all the provisions in many of the laws are compliant with TRIPS obligations, but that's what India has been defending vociferously, and that has been reiterated very strongly at the very beginning in the national policy as well, that India's laws are compliant with TRIPS. But that's the IP system we deal with. If we go to the next bullet, I will give you a little bit of an idea of the mindset that currently prevails so that you have an idea of where this policy really comes from and what the strength of this policy is. So the mindset, obviously, because of the traditional notions of intellectual property, is that of suspicion. there is a suspicion about why the international community is interested in an IP regime in India. And that's how it has been for several years. IP is looked at also as something that's more academic. It's not something that should really concern businesses. It's something that should probably just concern universities and researchers who come out with innovations and inventions and not really business. So that's the IP mindset we are dealing with. This mindset, however, is changing, and it's changing gradually, but definitely is changing. As India's companies are becoming more innovative, as Indian companies are earning more and more revenue out of R&D activities, India is realizing that intellectual property does have a role to play for business as well. And this change is coming in some of the government circuits as well. So moving on to the next bullet, that's where India's first national IP strategy came about. So this was as recent as 2012. It was called the strategy then, and this was something that was introduced by the Congress government. The strategy in its draft form was published, but it was extremely broad brush. It didn't really talk about IP for business, about protection of IP, or about IP enforcement. It only talked about IP for research and academic. It had an academic inclination on intellectual property. So, but that was the first draft. We see that after this strategy came, in 2014, if you could click on the next bullet, please. Yeah, in 2014, the new government came out. And the new government, the Modi government, if nothing else, the one thing that they really stress on and they have made very clear that they are interested in is attracting more foreign investment. And one of the sort of bottlenecks or one of the criticisms to India's investment scene that the Modi government has understood is the uncertainty around intellectual property protection and the less than perfect IP regime. So soon after they came into power, they set up a think tank comprising 3 individuals, they were all academics, to frame its first IP policy, is what they started calling it. The 3-member IP think tank came out with a draft policy, but that was again very academic in nature, a little similar to the strategy that had come out in 2012. The think tank was dropped unceremoniously, and another think tank was soon established, which was a 6-member team with some business representatives, a couple of lawyers, and a retired judge. And they came out with their first draft policy in January last year, 2015, and the government invited comments from all relevant stakeholders. The UK Intellectual Property Office also submitted comments and had meetings with the Indian government to explain what the UK businesses would be interested to see in an Indian IP policy. That happened, and then several other stakeholders also submitted comments, but then followed months of speculation, and we didn't really see anything substantive come out of this think tank after that. After months of speculation, in May this year, on 12th of May, we saw a final release of the National IP Policy. If we move to the next bullet, please. So it was finally released. The end effort was a little bit of a hurried effort, though, because we saw that none of the consultations were really taken on board. Not ours, but not a lot of other people from the international community. What the final national policy looked like was very similar to the earlier draft of the 6-member think tank, but that's what we have at the moment. That's where we are. Why it came out on the 12th of May, there are also rumors in the IP circuit here that the last push was a hurried or a hasty push because the government wanted the policy to come out before Prime Minister Modi was due to meet the Obama administration during his last visit to America, and they wanted to have something positive to show in the IP space, and that's why in the end it came out the way it did. So that's what it is. So there's the context. Let's move on to the next slide and talk about the content. If you want to have a read through the policy itself, it's available on the link right there, or if you want to read through some of the specific portions, that's where it is. If you move on to the next bullet, so what is the IP policy? The policy is basically a vision document. So it's a vision document. What does that mean? That means that it is not a statute that has been passed by both the houses of Parliament. It's not a rule, regulation or ordinance that has been promulgated by the executive. So it's not really an official notification, which means it does not have any force of law. One cannot hold the government accountable for not following the policy. It is only a direction that has been given to the government on any future policy making that should happen. So it does not have any teeth of its own. It's only an indication of the direction of policy making. What does it say? It says that it aspires for an India where creativity and innovation are stimulated by IP for the benefit of all. That's a heavy statement. That's a very huge aspiration. And as you can see, it's a very wide aspiration. This really sets the context for the policy. It is a very wide, all-encompassing, it is not focused on specific IP issues or on specific ways to administer or manage intellectual property. It's very wide. Moving on to the next bullet, if we see the mission statement, and if you could move to the next bullet as well, under the mission statement itself, you can see a sort of immediate need at the very beginning of the government to try and balance different stakeholder groups, the biggest two stakeholder groups in India, one being businesses and one being civil society. It shows the sort of nervousness when they say that they want to stimulate dynamic IP, but by fostering creativity on the one hand in order to appease business groups, but also very quickly they say enhance access to healthcare, food security and environmental protection to quickly appease any civil society groups. So this really sets the premise for any IP policy making in India. This is the bedrock of any IP policy making in India. There's this constant need to balance both of these stakeholder groups. So it's very important to note the mission statement. Now if we move on to the next slide, we'll talk about the specific contents themselves. In the first bullet, as you can see, there are overall 7 objectives that have been laid out in the policy, and each of these 7 objectives have specific steps that have been put forth for the government to take. Some of these steps are quite focused and they are narrow and they talk about specific activities, but some of the steps are very vague and ambiguous and are quite subjective and don't really point to any activity really. Also, none of these steps contain any timelines. So none of the objectives or steps talk about by when the government needs to do the activity that they aspire to do. So that's how it is. It also doesn't talk about which government department in the government is required to do that step. So it's all left quite open. The first objective is to create Ipr awareness, which is very positive, very good. They have acknowledged that there is a lack of awareness, not just amongst the general public, but also in some government circles. They talk about the low rate of IP filings by Indian applicants. So they want to really increase awareness. And how do they want to do that? They have launched a slogan called Creative India, Innovative India. And this slogan will be linked with many of the most successful campaigns that the Modi government has launched, like Make in India, Startup India, Skill India, Smart Cities, etc. And this will be the IP slogan that will be promoted. And with this slogan, they aim to conduct programs around India to generate sensitivity about the value of intellectual property for various stakeholders, not just the public, but for several businesses as well. And they want to focus on rural areas where some of some frugal innovation comes out and some unique intellectual property is seen. So that's the first objective. Moving on to the second objective, what they want to do is stimulate the generation of intellectual property. So they're talking about creating more intellectual property. And how do they want to do that? First of all, they aspire to conduct baseline surveys or IP audits of various sectors around India to find out what the IP strength of each sector is, and then customize programs around those targeted sectors. That's what they aim to do to generate IP. Now, ideally, what they should have done is actually conducted these baseline surveys before coming out with the policy, and then in the policy talked about the specific programs that they want to target in those sectors. But well, anyway, they are going the other way around, but that's what it says, conduct baseline surveys. They also want to strengthen IPR facilitation centers. Now, at the moment, there are only 3 facilitation centers that are not even fully government centers. They're quasi-government. They've been created by an industry body, and they are seriously understaffed and heavily underpaid, and frankly, nobody knows what they do. So maybe the aim is to strengthen those or to create more IPR facilitation centers. So that's something that they are aiming to do. They are encouraging open source drug discovery to make medicines cheaper and come out with cheaper versions. So that is something that we've mentioned. And also promote tax benefits to incentivize creation of intellectual property. So that's what they're talking about in the second objective. If we move to the third objective, now this objective is about strengthening the legal framework. Now, to me, this is really the biggest opportunity that they had to bring about real change, but also the biggest letdown. There was a real opportunity in this objective to really plug some of the loopholes in the existing laws in India. But instead, they have what they have put forth is all quite subjective. They say review where necessary, which is extremely vague. They talk about engaging constructively in negotiation of international treaties, which specifically and how is not mentioned. And they talk about some extremely non-contentious areas that they aspire to do further study. For example, penal provisions for copying films, which is a US pet subject. Interplay of IP law and competition law, guidelines on patents and biodiversity, and trade secrets. What they haven't done is given more clarity on what would qualify for compulsory licensing, whether what local working requirement is. They haven't given more clarity to Section 3D, what would qualify as an incremental innovation and what wouldn't. They haven't even clarified or struck down a law in the Patent Act which requires an applicant to give details of all international applications around India, around the world before making an application, basically just adding to the delays. So there were real things where they could have brought a change, but they really haven't. But what they have mentioned is good. If some change comes out in any of these, that would, of course, be of some benefit to businesses. But for me, there was real potential here, which hasn't really been tapped. If we go to the next objective, it's the fourth one. This is quite positive. Now, they're talking about modernizing the administration and management of intellectual property, especially the IP offices. The most positive thing that has come out of this policy, and this is something that has been implemented even before the policy was announced, was bringing in all intellectual property policy making under one umbrella. So the Department of Industrial Policy and Promotion is now responsible for copyright and semiconductors as well. Earlier, copyright was under the Department of Higher Education. which came with a completely different perspective, and it was a complete misfit. DIPP comes with a business perspective, so it's good to have copyright under them. And also it's now basically one place where you can go to for any IP-related policy issues. They've also made the Controller General of Patents, Trademarks, Designs, and GIs responsible for copyright as well. So he's going to be called the Controller General of IP, and the Copyright Office will sit under him. So again, all rights granting is also under one umbrella, and it's the Controller General's office that will have the authority to administer all IP. They've also created a cell for IPR promotion and management to facilitate creation, commercialization, and management of IP. How it will be created is not yet clarified. They talk about augmenting manpower, about refurbishing the ICT systems in the IP offices, and they also talk about expedited examination of some patents for manufacturing growth. So these are some other positive notes that have come out. Which patents is not specified yet. But all of this is quite positive. And things have actually been happening over the last 4 or 5 years where the Controller General's office has actually been trying to modernize its systems. Of course, for this to translate into real change on the ground will take time just because of the sheer number of pending cases in the IP registries at the moment. Going on to the next bullet, the fifth objective is promoting commercialization of IP, which again is quite a cliche. I think 1, 2, and 5 are things that you would have expected in any IP policy anyway, and not really, solid. They talk about building a public platform for IP exchange, IP valuation, and tech transfer. It's good that they talk about IP valuation. It's about time India started thinking about IP valuation, and I know that it's quite a hot topic. Over the last few months, it has become, at least in some IP circuit. The next thing that they mention under promoting commercialization is a little more worrying. It talks about providing financial support to less empowered IP owners. Less empowered IP owners is very subjective. Who decides who is less empowered and who isn't? There's no clarity on that in the policy itself. It also says in section 511.5 that the Technology Acquisition Development Fund may be used to help them procure patents. Procure patents by buying them or by CL. I mean, compulsory licensing could also be a way in which they could procure patents, and that is slightly worrying. But there's no clarity on that, but that's what it says at the moment. So we will have to keep a watch out for this. Moving on to the sixth objective. This again is a very important section. It talks about enforcement and adjudication and how they aim to strengthen it. Again, for me, ideally the best case scenario would have been that they go further than just aiming to build capacity of the current authorities that are responsible for IP infringement to actually bring in some specialized agencies to deal with IP crime. So they have stopped short of doing that. They haven't created any specialized wings in the police departments equipped with the knowledge and the infrastructure to deal with IP crime. They haven't even set up specialist IP courts or specialist benches within the courts that are currently there. So there is no specialization that they are looking for. It's only about training current police officers, which anyway has been happening for many years. And the desirability of adjudicating IPR disputes through commercial courts, which will anyway be quite overburdened, and it's not necessary that judges in these commercial courts will be IP experts. So it's not gone to the perfect case scenario, but at least it's some improvement, looking at the bright side. So, so that's the sixth objective. Moving on to the seventh one. It talks about strengthening IP human resources, which is good. Talks about empowering Rajiv Gandhi National Institute of IP Management, which is responsible for training all IP examiners, talks about including other training, so training of law attorneys, etc. as well in this, which is good. But more importantly, it talks about introducing IP in, education in schools and colleges, which is quite interesting, especially IP education in law colleges. Some of you may be aware that not all law colleges in India have IP law as a subject, with the result that there may be a case where your future IP attorney or a judge potentially hearing an IP case would not have studied IP law in their law course. So it's good that they aim to make IP education compulsory in institutes of higher learning. So that's good. So these are the different objectives that have been set out. If we move on to the next slide, let's put some thought into what this might mean for you. So as you can see, there are a lot of different objectives. There are a lot of different aspirations that the government has put forth, but nothing really groundbreaking. It doesn't really dent the IP regime in any way. It's more business as usual, really. But what does it mean for you? Does it mean anything? Well, at the very least, looking at the bright side, it is an indication that India is keen to welcome foreign investment. They have tried to put forth something positive in the IP space, which can be seen as an indication that they are open to thinking about change. So for you, what this might mean with the new government and the new people in the government circle is a real IP issue that you and other similar companies in your sector have, then the government should be more willing to listen to you and should be more willing to think about how to sort that out. And we have seen that in the last few months, that if there are specific issues that are quite sticky in the IP space, then the government is willing to listen to us. So if you have any such issue, please bring it to our notice. My coordinates are in the first slide.
We are just facing some technical issues. Please bear with us. We'll connect with Anshika in a moment.
Hello? Hi, sorry. I think my call got dropped somewhere there, but I hope everybody can hear me.
Yes, Anshika, we can hear you now, and I think we are good to
Excellent.
go. I believe we were discussing the
Ex-
first point. Yeah.
Yeah, I don't know exactly where I got dropped off, but what I was meaning to say is that this is as good a time as any to really bring any issue to the notice of the Indian government here with the newfound interest in unblocking some intellectual property issues. So do bring it to our notice. If we move on to the next bullet, the other positive that we see really is that all decision making now comes under one umbrella. So it really makes our life easier because one, we can go to one department and one person in that department to raise any intellectual property related issues, whether it be relating to patents, designs, or copyrights. And two, also because that person comes with a business perspective, being a part of DIPP, he will have all different issues in mind and all different issues will come to his notice, so he will be more willing to sort them out. So that's another positive that has come out. Moving on to the third bullet. The other positive is that there is definitely a stress on awareness, and this is probably, if nothing else, then an attempt to bring out more awareness in government circles about intellectual property and also amongst the public. At some point, what this would mean would be pro-business policy making on intellectual property, but also with the sort of programs that they want to conduct for the general public, it might also mean that the public is more aware about not buying counterfeit goods, not buying fake goods. So a lot of the market that had been encroached by the fake goods come back to the IP owners. So that's another positive that's come out. The fourth bullet, if we move on, says that as we see that the policy aspires to make filing and registration easier, that's definitely another positive because it's really the backlogs and the problem with the quality of examination that we see in India with IP registrations that they want to sort out, and that would be really positive for all of us. Like I said, we've been seeing over the last few years, they have tried to recruit many more staff. They have improved the infrastructure of the registries, not just the physical infrastructure, but the IT infrastructure as well. And that is going some way to reducing the delays. Of course, there will be another few years until registrations become more easy and the quality really improves, but they are making some effort, so that's positive. And in my last bullet, if we move on, so we've seen a lot of different implications for you, but implementation really remains a question mark. There is nothing in the policy itself that talks about setting up a task force or a committee to review in a few years' time the progress that's been made with the policy coming out. So we don't see any implementation mechanism. We don't see any schedule or any timetable in which they want to fulfill the commitments under the policy. So there's nothing that's really clear or crystallized as to implementation in the policy itself. And the policy, like I said, doesn't have any teeth because it doesn't have any force of law anyway. It's only a direction given to the government on any future policy making. That said, please do note that the biggest value of this policy is that if a case does go to court, if an infringement or IP protection case goes to court, the judge will be obligated to have a look at the policy in order to determine what the government wants India how the government wants India to deal with IP, and the direction of the government's IP policy making. And the direction definitely that the policy shows is a very positive direction. It does show that India is becoming more keen to protect IP for business, and there are some reflections of pro-business IP policy making that come out of the national policy. So the court will have to be a little more pro-IP than anti-IP going forward. So that's the biggest positive that we see. So what I would say, parting words would be that it's definitely, looking at the bright side, it's definitely a good piece of work that we've seen from the government, and it's a first on intellectual property, and they are giving an indication that they are more open for business, and they are keen to sort out any difficulties that IP owners face in India. So that's what it is. If you have any specific questions on the policy or otherwise, I'm very happy to answer them now. Or my first slide has my coordinates. You can get in touch with me over phone or email me if you don't want to share your query just now. Thank you very much.
Many thanks for that excellent overview, Anshika. I will now ask some questions we received. The first question is, in your opinion, how important this IP policy is in making it easier to do business in India, especially for foreign companies? I mean, is it a big step or is it still a small, tiny step?
Thank you very much. Like I said, I think it is definitely not a big step. Like there is nothing significantly that's changed for foreign business or Indian business in the IP regime in India, but it may translate into real change going forward. If nothing else, then at the moment, because of all of this newfound interest, if there are specific issues, then we can raise them with the Indian government if they can be sorted out diplomatically. So, yeah, maybe positive down the line, but no big steps.
Thank you, Anshika. The next question is, for exporters to India, in cases where IP has been registered elsewhere, for example in the UK, covering the goods being sold, will an additional IP registration be necessary in India in order to ensure that IP is not copied?
Thank you. IP policy or no IP policy, yes, you will have to register your product, the trademark in your product at least, in India before exporting it. If your product is patent heavy, then please consider registering your patent as well, but definitely your trademark, because it's very easy to copy trademarks and counterfeit goods here. So yes, you have to register.
Thank you, Anshika. The next question is, what are the IP laws around data protection?
Currently, there are no IP laws around data protection. That's something that could have been addressed in the IP policy as one of the things in which they could do further study on, but that has not been addressed. There is a very small provision in the IT Act which talks about data, but it doesn't go as far as protecting data as an intellectual property. So no, there is nothing currently to protect data in India.
Thank you, Anshika. The next question is, how would you think the perception of India's IP regime has changed in the last 2 years, especially since Modi government took charge?
In the last 2 years, well, over the last many years, the perception has been quite negative. India has been consistently ranked the lowest in the Special 301 report, for example, and in many other innovation indexes. And one of the reasons why this policy came out, and one of the reasons why we haven't seen another compulsory license after Bayer, is this negative publicity. The perception has not changed over the last 2 years. I have had meetings with counterparts from the United States working in India after the policy came out, and they're not really excited about it yet. But they are happy that no court case of the kind of, Bayer or Nexavar or, the Section 3D case has come out after 2013, 2014. So they're happy about that, but the perception is still very negative.
Just adding on to that, Anshika, what's your view? Is the perception worse than reality, or it is, that's what the reality is?
I think it's very close to reality. The laws are definitely there, and they are more or less compliant with TRIPS. There are mechanisms to enforce those laws, but like I said, the mindset is still very much questioning intellectual property regime, and more importantly, enforcement of intellectual property is very poor. There are some high courts around India, especially the Delhi High Court, that have been taking a pro-intellectual property and a pro-business stand, but that's only one, that's only one union territory. There are 7 union territories and 29 states around India. And not all high courts have picked up the way the Delhi High Court has. So enforcement is still very poor. The police still doesn't view intellectual property crime as a crime, even when it is something that that falls under the Criminal Procedure Code, CRPC. They think that they have other bigger crimes to deal with, and IP is not given the kind of value it should. A lot of times IP owners themselves have to try and tackle IP crime or engage third parties and lawyers to try and tackle them. But it's not automatically something that the machinery, the state machinery tries to tackle. But things are changing. Things are definitely changing, especially with Indian companies becoming more intellectual property heavy. But there's a long way to go, and the perception is very, very close to the truth.
Thank you, Anshika. My last question, you have addressed parts of it, but in case you would like to add anything to it, the question is, what do you expect from the government from this policy, and does the government have any concrete plan to put in place this policy?
One thing that we could expect is refurbishment in the IP registries. I know that more than 200, I think around 250 new examiners have been recruited for trademark and patent examination recently. So one solid change would be modernization of the IP registries, but nothing more than that. I do not see any change in any law happening in the near future. I don't see any change in the way IP is going to be enforced in the near future, but the only change I see is positive changes in the IP registries.
Thank you, Anshika, for the excellent overview and interesting insights. Thank you very much for your time, and I hope this webinar was valuable to you. If you have any feedback or comments about today's session, or a session that you'd want to see us do in the future, please feel free to get in touch. Thank you for joining us.
Thank you.